Hello and welcome to you all. I'm Barbara Brown, Clinical Director at Redbird Therapy, and I'm a registered psychotherapist. And we are super excited to have Jana Tsang with us today. She's a wills and estate lawyer, super smart gal. And one of the things for us, if you're a mental health professional, is in a regulatory position, we really need to be thinking about how we take care of emergency circumstances. But the good thing about tonight is it's not just going to be about that. So if you're not in our field and you're watching this, Jane is going to bring you a ton of useful information about your personal will and estate planning so that you can be in a really good position. I'm going to hand it over to Jana. Questions are absolutely more than welcome, and put them in the chat, or we'll have periods of Q&A as we go. Jana, over to you.
All right, thank you so much, Barbara. So let me get set up here and start presenting. But while I get set up, just to tell you a little bit about myself, I've been in practice since 2009, and I started my own practice in 2018. So I've been on my own for about 6 years now, and practicing primarily in wills and estates and also family law. So, all the fun stuff. And let me just share my screen here. So I talk to clients on a daily basis about wills and estates planning, why this is important. Barbara, just wanted to double check with you. Is my screen showing up?
Yeah, you're looking really good.
Okay. All right. Okay, so the topic for today, obviously you guys have joined, you guys know what we're talking about. We're talking about, is your practice ready for an emergency? What are some considerations that you should be thinking of and putting into place in terms of protecting your practice, protecting your clients, and also protecting yourselves and your beneficiaries? All right, and just a disclaimer. So this is just something I have to say. This webinar is for general information purposes only. I'm not giving legal advice during this webinar, but if you do want legal advice, contact me after the fact, and I'm happy to set up a consultation with you. All right, so what do these people have in common? We have Amy Winehouse, we have Bob Marley, we have Prince. And for all three of them, very different genres of music. They've all passed away at different times. The one link in common, though, is that they all died without having a will in place. So for Bob Marley's estate, it was in litigation for 30 plus years. Prince passed away in 2016. And because he died without a will, there was ongoing litigation, and that wasn't settled until 2022. So that took about 6 years for that to be done. With Amy Winehouse, she passed away without a will. As a lot of us are aware, she had a very contentious relationship with her father. Because she passed away without a will, her parents ended up being her beneficiaries, even if she may not have wanted them to have everything of her estate. So clearly, and we may or may not think that wills are important, but through these people's examples, and we may not have the same dollar value in terms of our estates when we pass away, but still very important to make sure we have these documents in place to make sure that our assets go to who we actually want it to go to, and to have proper decision makers in place. So first topic we will touch on today is, what is a will? So a will is a legal document that allows us to decide what we want done with our stuff after we've passed away. So this document only becomes effective after someone's passed away. In this document, for more simplistic matters, it allows us to choose who we want our executors to be. Executors are also commonly referred to as estate trustees, one and the same thing. They are the people that we are putting in place to manage everything after we're gone. So they have to take control of our assets, they have to pay off our debts, make funeral arrangements, pay off income taxes, And then when all of that is said and done, then distribute the remaining assets to our named beneficiaries. So very important person that we are putting in place. This should be someone that you trust, who will not abuse the powers that we're giving to them, because we are giving them lots of different powers to deal with the assets as they see fit. The next big piece in terms of the will is the beneficiaries. Beneficiaries are the people who will get whatever assets that remain after the payment of debts, expenses, and taxes. Beneficiaries can be whoever you want it to be. So it can be, spouse, children, other family members. It could also be charities, friends, whatever the case may be. And last but not least, for a lot of us, the will allows us to name guardians for any children that we have that are under the age of majority. So for guardians, this is someone that we are asking to take our minor age children into their homes, or for them to move into our homes to raise and care for them as we would. And so again, we would want to make sure that whoever ends up being the guardian is not someone who is just in it to get control of the kids' trust funds, that they have a genuine care and concern for our kids, and that they're going to do right by us. All right, so some common myths for wills. The first myth is, I don't need a will because everything will go to my spouse anyway. So it's a yes and a no answer. So when we die without a will, this is what happens to our assets. So if you are in a married situation, the first $350,000 worth of your assets will go to your married spouse, or your married spouse can also make an election under the Family Law Act. What that means is that because the law treats the instance of death as a breakdown of the relationship, if your spouse at that future time feels that whatever they're getting from the situation is less than what they would get if there was a separation, so if there was a breakdown of the marriage, they can opt under the Family Law Act to treat this particular instance of death as a separation and get their entitlement under the Family Law Act. So for the remaining assets, if there are no children, everything goes to your married spouse. If there is one child, then your married spouse and your child divide the remaining assets equally. If there's more than one child, the married spouse gets 1/3 of the remaining amount, and then the remaining 2/3 are shared by the kids. So whether that is 2 kids to 6 kids, or however many kids you have, all of them share the remaining 2/3. If a child died before the parent, but they have children, so you have grandchildren, then the deceased child's share would be divided amongst your grandchildren from that child. Now, if there are no married spouse, children, or grandchildren to inherit, then the next order of inheritance is, first, if your parents are alive, they inherit. If no parents are alive, then it goes to siblings. If there are no siblings, then it goes to any nieces or nephews that are alive. And then after that, essentially anyone that can prove any kind of blood relation to you. And then ultimately, if there's no next of kin, then the estate becomes the property of the government. So some people think that, like if I die, then everything goes to the government without a will. So that's not exactly true, because there is this order of inheritance in place. So who gets left out in the cold if we don't have a will? You notice that in my previous slide, I make a lot of mention about married spouse, and I keep harping on that married spouse piece. And that's because the legislation does not treat common law spouses the same as married spouses. Common law spouses do not have any automatic inheritance entitlements from someone's estate. So what common law spouses would have to do is to sue the estate as a dependent and to try and make claims that way. Other people that get left out of the situation is, if the deceased person had elderly parents that were relying on them, or maybe if they have an adult child with disability, and the intention would have been maybe to give that adult child a bigger portion of the estate, or whatever the case may be. Because this person died without a will, we have to default to what the law says in terms of who gets what, and we can't make special allowances for other people unless all of the other beneficiaries agree. As well, any other relatives that maybe you would have wanted to provide for since you died without a will. If there are people that are higher in the totem pole in terms of inheritance, then they won't get anything. As well, with respect to stepchildren, stepchildren does not include adopted children. Adopted children are treated as um, um, children that bear your blood. But if they're just stepchildren, even if you do have wonderful relationships with them, even though you would have wanted them to get something from you, if they are not in your will, they do not have any automatic entitlements. And last but not least, if there are friends, other people in your life, if there are charities, nonprofits that you would have wanted a portion or all of your estate to go to, none of that can happen unless you have a will in place. So I have a quick example here of someone dying without a will. So let's say John died without a will. John was married to a spouse. They had 3 children. The family home was in John's sole name. And John's total estate at the time of his death is 1.5 million. So after the deduction of debts, expenses, taxes, administration expenses, the remaining amount in the estate is 1.2 million. And the key point here is the family home is the biggest asset of the estate here. So it's valued at 1 million. So that forms, the biggest piece here. Oops, sorry. So if his spouse, let's say we call her Jane, his married spouse will get the first $350,000 of the 1.2 million, and then the remaining 850,000 would then be divided between Jane and his 3 children. So Jane gets 1/3 of the 850, which comes up to about 283 and change. Each of the remaining 3 children splits the remaining 2/3 share. Which means that the 566,000 and change here divided by 3. So per child, each child inherits 188,000 and change. Now, because the biggest asset is the family home, John's spouse may have to sell the home in order to satisfy the children's beneficiary entitlements, unless he or she is able to qualify for a mortgage if the intention is to keep the home. One more consideration I want to add here is that if the children in this particular example are under the age of majority, the Office of the Children's Lawyer, which is a government agency, I'm sure most of you are aware of who they are, they will become involved, and they will essentially be the ones holding the money in trust for the minor age children until they reach the age of majority, which is age 18 in Ontario. And so that means that instead of the other parent being in control of the kids' trust funds, now the government is involved. All right, myth or misconception number 2. Many people think, I don't need a will because my situation is simple. And it can be. If you're someone who does not have significant assets, like, if you just have a bank account and you don't own any property, you don't have any shares in a business, or you don't have your own practice or anything like that, maybe, and if you're okay with, how the government says your assets are to be divided, then that's, obviously totally up to that particular person. But in terms of, debunking this myth, some questions to ask is, 1, do you want your family to fight over who will be appointed as the executor, or who might be the guardian of your minor age children? Again, unfortunately, there are people out there that will apply to be guardian of young children in order to gain access to their trust funds and then to use the kids' trust funds for their personal gain, like using the kids' funds to buy a bigger house, with the rationale being that, oh, well, I need a bigger house to have these kids live with me, and then instead, using all of the kids' trust monies to fund that purchase. A second consideration or question to ask is, do you want to leave a specific gift to a particular person? And also, if you are estranged from a particular family member, since the law treats all relatives the same way. So whether you have a great relationship with them or not, the law doesn't care about that. Just like the Amy Winehouse example, even if she had a terrible relationship with her father, he still got to inherit from her assets because she died without a will. Third consideration, if you're separated from your married spouse, but you haven't finalized the divorce, do you want this person to inherit your assets? And this also applies to common law spouses as well, but to a lesser degree because married spouses have that automatic entitlement, whereas common law spouses do not. And another consideration here, and these are my babies, but do you want your pets to be cared for by a specific person? Do we want to make sure that your pets will be taken in by someone that will love and care for them, and that they won't end up in a shelter and that type of thing. And because I'm a crazy dog mom, I did apportion some funds in my will for the food and care and just general well-being of my dogs. So that is a cash gift to go to the person who is taking care of my dogs after I'm gone. Okay, myth number 3, I'm still young and I have time. Or some people think that if I make a will now, then I will die soon. So it's a bit of a self-fulfilling prophecy. So my answer to that is not to be grim, but we're all going to die at some point. We don't know when that's going to be. Our hope is that, we will live until we are long in the tooth, but unfortunately that doesn't always happen. And so now is always a good time to get your documents done and get them put in place to make sure that you don't have to worry about, whether your family would be financially okay after we're gone, or that, your assets will end up in the hands of someone that you don't actually want it to go to. All right, so just to recap, who needs a will? So technically speaking, everybody should have a will, but these are the people who really should have wills in place to make sure that the people in their lives are protected. So again, parents with minor age children, very important to make sure that their beneficiaries are structured correctly, they have proper guardians in place. People in common law relationships, if you want your spouse to get something from your estate without having to incur extra legal fees to sue the estate for entitlements as a dependent, then get your documents done to make sure that your intentions are set out and will be carried out. For people who are going through any changes in marital or relationship statuses, so people entering a new relationship, people exiting a relationship, people entering into subsequent relationships. So when we're entering into a new relationship, the consideration is, okay, do we need to provide for our new spouse? If so, how much of our estate is going to them? If we are exiting a relationship, then, a lot of times it's making sure our ex-spouse does not get anything that they're not entitled to. And then for a lot of us who are entering subsequent relationships, so like, let's say they've had their first marriage, they have children from their first marriage, they obtain a divorce, and then they are now in a new relationship. So in the new relationship, there are now different considerations for the estate planning piece. So what is the intentions for the new spouse versus providing for children? How do we balance it? And so we have discussions around all of that. Other people who need a will, people who have existing cohabitation agreements, prenups, marriage contracts, things like that, or ownerships in the family business to make sure that those shares are transferred properly and again to whom it's intended. People who are estranged from particular family members. Again, if you recall, if we die without a will, then it goes according to what the law says. So, it's married spouse, children. Then if there's none of that, then it's parents, siblings, nieces, nephews, that type of thing. So if you don't want your estranged family member to have anything, then that's where having a will in place is very important to make sure that they do not get anything that you don't intend to. If this person does not have any relatives to inherit, instead of money going to the government, maybe they want money to go to friends. Maybe they want money to go to charities or NGOs or whatever the case may be. And like I mentioned before, If you die without a will, even though the intentions are there, unless you have a will in place that says that this is where this percentage or this dollar amount is going to go to this particular charity, that's not going to happen. All right. Okay, benefits of a will. So I'll just go through this quickly. So you get to choose who your executors are going to be. You get to structure your beneficiaries. In your will, we can also put specific bequeaths. So if there are particular personal items, so, you know, some people have family heirlooms that only go down the female side of the family, or something like that, and that type of thing. It also allows parents to set the age of inheritance for children. So if age 18, which is the minimum age for someone to inherit, is, you know, they around the age of someone graduating high school, if they feel that it's too young, they can set the age of inheritance higher to make sure that, you know, they'll be a little bit more mature to make get access to the funds at a later point in time. Will also provides parents with a choice in the guardian, so it's not just anyone stepping up. In the will, we can also designate any funeral arrangements or pet care arrangements. With the will, which I'm not diving into this particular seminar, but if somebody has a corporation, so privately incorporated business, so whether they have a personal operating company or holding company, there is a corporate will that we can put in place to transfer the ownership of the shares to the beneficiaries outside of the probate process, and there are different considerations around that. As part of the will discussion, there is the estate planning piece, which goes towards minimizing the estate administration tax. The estate administration tax is an additional tax to income tax that's payable to the Minister of Finance, and that's extra money going to the government. So wherever we can try to minimize that, we try to do so. And last but not least, having a will in place helps the people that you leave behind avoid a lengthy estate administration process and potentially avoid litigation as well. Okay, so diving into something a little bit more specific to psychotherapists is the professional will piece. So what is a professional will? Professional will is a document that is an additional document to your personal will. The professional will allows you to name someone to deal with your practice, and essentially to wind down your practice. And so as part of this professional will, you are asked to appoint a professional executor, so someone to assist with the management of your practice. The consideration here is that it's preferable if it's a fellow colleague, because the rationale there is that they already have an understanding of the requirements are in terms of, you know, maintaining client records, client contact, and, you know, general rules, regulations, and ethics and everything to do with your profession. It's my understanding that it's not a requirement for your professional executor, at least for psychotherapists, that it has to be a fellow registered psychotherapist, but I think it is recommended. And certainly if you don't have someone in your life that you can name as your professional executor that is a registered therapist, I think the recommendation there is to have someone who's well-versed in healthcare law and regulation so that they understand or they're able to understand quickly what the requirements are and to do things properly. So what goes into your professional will? Your professional will, so again, like I mentioned, will designate the professional executor who will just deal with the management of your practice. The document will also contain a list of powers and duties that we are asking them to complete. And so these are just some examples, and a lot of this I pulled from the CRPO regulations and bylaws. They're required to secure and manage client records as required by the applicable legislation, codes of conduct, or regulatory bylaws. We're asking them to manage your active cases. So in this particular case, it's in managing and also winding down, right? We're asking them to provide active clients or patients with appropriate and timely notification of the practice closure and also how they can access their records. We're asking your professional executor to offer assistance to find another service provider. And we are also asking them to address essentially all administrative issues pertaining to the practice closure. So things like, managing, existing office space, cancel leases, get in touch with landlords, close bank accounts, transfer client patient files, provide notice of closure to the public, whether that's, notifying the regulatory body, and as well updating any websites that you may have to make it known that you are no longer in practice, that this is being wound down, and to provide contact information to people who are looking, existing clients who may not have known. Now that they're aware, who they should contact in terms of getting their documents transferred. Okay, so before we move on to the powers of attorneys, Barbara, do we have any questions?
No, we're doing okay, but let's just take a beat and see, because that's a lot of amazing information. Folks online, are there questions that you're carrying either about the personal will and executor or the professional one? One of the things I will say as a RP is I chose actually to formally write, with a lawyer, do a professional power of attorney and will document. It just felt to me like it was a really steady choice, protective choice, and that process helped me articulate then with the people who are stepping in to do that. What do I need to do to prepare them to take on that role? What information do I have to gather so that when they step in, it makes their job easier? So it's been an interesting thing in ensuring that I have a professional will in place. I have to really think about what are the other pieces that I prepare for that executor. And I think it's worth it, to take that time.
Absolutely. Yeah, so I have slides later on in terms of, some contingency planning pieces. So we'll get into that a little bit more, but definitely, Barbara, like you said, around the professional executor piece, very important, obviously, to identify who these people will be. Beyond that, you should also let them know and have a chat with them so that it's not going to be a surprise that, something's happened and they get a call from someone in your life saying, oh, Barbara's gotten to a car accident, you're named as the professional executor, and they're like, what now? And how do I find information and that type of thing? So
yeah,
very important
we
to
don't want
have
that to have happen.
Those are not good surprises to have.
Okay.
All right, should we
Oh,
keep
wait.
going?
Here we've got one quick little question. Let's see. Amanda, you may get to this, but I'm wondering if a professional will needs to be prepared by a lawyer. I've created a professional will and I've made copies that are stored with my personal will, and a copy with the professional executor, but it hasn't been seen by a lawyer. Great question.
Yeah. So thanks for your question. Professional wills and even regular wills don't have to be prepared by a lawyer. So the only piece I will say about this is that when it's prepared without a lawyer, some of the considerations there is, does the document contain everything that it needs to have, right? So I've less concerns about a professional will, but for personal wills, there are some mandatory requirements for a will to be deemed to be valid. But if, let's say, you have a template from your regulatory body, and this is sort of, what everybody uses, and, just make sure that it's signed and witnessed properly. But yes, it does not require to be done by a lawyer. All right. So I will get moving then. Okay. Next set of documents that I will talk about are powers of attorney documents. So power of attorneys you guys may know already, but just to be clear, these are documents that allow someone else to assist us while we are not able to do things for ourselves. So a good example would be if I get into a car accident, I'm in a coma, I obviously can't tell the doctor what treatment options I want. I also can't make sure that there's enough money in my bank account for the mortgage to go through, or my credit card bills are being paid on time so I don't get charged interest. And for RPs like yourselves, you know, aspects in dealing with your practice, how will my clients be notified? Who will be the point person to do all of these things for me? So that's what powers of attorneys are for. They allow us to name our substitute decision makers. These documents are only effective while we are still alive. After we've passed away, then the will takes over and the powers of attorneys are no longer effective after that point. With the powers of attorneys, there are two main types. The first type is the power of attorney for property, and that is the document that allows someone else to manage our assets as if they are us. This is a very powerful document because this allows someone else to deal with all of our assets and debts. So they can buy a house in our name, they can sell a house that we currently own, they can make mortgage decisions. So whether it's to terminate a mortgage, take on a new mortgage, renew a mortgage, that type of thing. They can make investment decisions on our behalf. They can take out personal loans in our name, move money around, all of these things. The only thing that your financial attorney cannot do is they cannot make a will in your name. They also can't change your existing will. So whoever you may choose for this personal power of attorney for property, should be someone that you trust will not misuse the powers that we're giving to them, that we trust that they're going to manage our money for our benefit because that is the job, and that they're not going to be in it to get something from the situation. So like, to try and sneak money from our accounts and transferring it to themselves and that type of thing. For the power of attorney for property, there's also a sub sort of type, which is the professional attorney that allows someone else to manage our practice. So the professional attorney for property will work side by side with your personal financial attorney. But with the professional attorney, their scope is much more limited because their scope is solely focused on maintaining or managing your practice during any periods of incapacity on your end. So whether that's a temporary thing, because let's say if we're in an accident, we will recover in 3 to 4 months, then we're just asking this person to step in for that short duration. Or in situations where it's a more serious issue, let's say I'm in a coma, then this may be a more permanent thing, or it may be a situation where we're asking them to wind down our practice because it's not looking like we're going to return to the practice. For the power of attorney for personal care, that is the health and medical power of attorney document. For the health power of attorney document, we can put in your documents if you have any preferences with respect to organ donation, if you have any medical directives with respect to end of life decision making and that type of thing. And all of this is meant to act as guidance for your personal care attorney. And for the attorney for personal care, it's not limited to just medical decision making. This encompasses all of our day-to-day decision making as well. So if you think about it this way, if I'm in a coma, my health attorney now need to decide, is this a situation where on top of making medical decisions on my behalf, are they keeping me in the hospital? Are they moving me to palliative care? Are they moving me home and hiring day nurses, night nurses to come and take care of me and that type of thing? If it's a situation where I'm being moved to a home or palliative care facility, which facility will I be moved in? And once I'm in that facility, what is my nutrition plan? What is my hygiene schedule? So all of these things, all of these day-to-day decisions that come so naturally and easily to us. We make these things without a major thought. Now someone else has to make all of these decisions for us. So again, whoever we choose as our people for personal care should be someone that have a genuine concern for our welfare. They are doing this to help us, to take care of us. They're doing this because they like us and they want us to be as comfortable as possible. Okay, so moving on to the contingency planning piece. So the first slide I have here surrounds the practice piece. So if you do have a practice, then these are some things that you should consider in terms of when you're putting your plan together. In my discussions with Barbara, I know it's a requirement for RPs under the CRPO to have a contingency plan in place. And so some of the considerations here, and a lot of you may know this already, but just to go through it quickly. So first, again, for the people that we're naming as your professional attorney for property to manage your practice during any periods of incapacity, or for your professional executor if we've already passed away. As part of that contingency plan, you should identify who this person or people may be, and you should also have that discussion with them and obtain their consent. And in terms of structuring these people as well, when I talk through these things with my clients, I ask them to think about it in a waterfall situation. So having a primary person and then having backups to the primary in case the primary person at the time of our accident or our death, they can't do it for whatever reason. So if they've passed away before us, or they've moved away, or they're of ill health and they can't take on something like this that we're asking them to do, that we still have backup people that we trust and that they're equipped to deal with what is required for us. Second consideration here, so create a plan for your designated person to notify your clients about your absence and any potential expected duration if they have that information available. It's good to maintain a list of alternate service providers for your designated person so that they can refer your clients to other qualified professionals who can address their needs, so whether on a temporary or permanent basis. We want to ensure that your designate has the ability to give your clients or their new providers access to any relevant client information that is in your possession. And last but not least, it's very important to maintain detailed information for the administration of your practice. So, having your designated person know the location and access of where your clinical and as well administrative files are. Where your contact lists can be found, where your client records can be found, if there are any particular directions for contacting clients or their representatives, contact information for alternate service providers, location of keys, passwords, list of passwords, landlord contact information, insurance information, banking information, etc. One point that I didn't put in here, but also important to keep with your practice documents, is the contact information for your personal attorney for property and as well personal executor, because your professional attorney and professional executor will need to work in tandem with your personal designated people to make sure that they get access to records and keys and that type of thing. Okay, and then contingency planning on a personal scope. So when we're talking about your personal assets and things like that. So again, first and foremost, identify, obtain the consent of appropriate people to act as your financial attorney or your executor. Share with your personal care attorney if any medical directives or funeral preferences that you may have, because they will be the ones to make these decisions for us. Keep a list of contact information for all named attorneys, executors, as well as backup people, including professional attorneys and professional executors. Let your financial attorney and executor know where your legal and important documents can be found in case of emergency. A lot of clients ask me, where where they should store their wills and powers of attorneys when the documents are done. And some of them think like, oh, maybe I'll put it in the safety deposit box I have with the bank. So I would say that usually that's not recommended, only because with bank safety deposit boxes, unless you're the box owner or an assigned, like an authorized representative, and also you have access to the key, you will likely have your people will likely have a very hard time getting into that box when something happens to us. So just keep your documents somewhere in your house. Let your people know where it is. If you want to share, electronic copies of them, that's totally up to you. There's no requirement that you provide them with that information, but it's very important that they know where to find it in case of emergencies. Next point, maintain and keep updated a detailed list of all assets and debts in your personal name and keep them with your documents. So much of our life is online these days. Like, there's no more, hardly ever anyway, bank statements being printed and mailed to our homes, and we're keeping physical statements, in our banker boxes and that type of thing. So instead of your financial attorney or your executor, trying to run around and dig for statements to see where you may have a bank account or you may have investments and that type of thing, having this detailed list of assets helps your financial attorney and your executors hit the ground running much faster. So, they have a targeted list of assets. They know, okay, I know Jana banks at Bank of Montreal. This is the account number. I can get in touch with them right away to let them know Jana passed away. I am the named executor. We're going through the probate process. And we now need to, start converting assets into estate accounts and that type of thing. Another consideration here is that if you don't have that listing of assets, there's a possibility that assets might get missed. And then that just means that that particular asset is just sitting with that particular financial institution with nobody to claim it. So, let's say I had a Tangerine account that nobody knew about, and I don't have any statements in my house, and nobody knows about it, and I had $50,000 in it. That's $50,000 less that could have gone to pay bills or gone to my beneficiaries. If my executors or financial attorneys had known about it, then they would be able to contact a financial institution to get access to that particular asset. And then the same thing with debts. One of the key duties of our financial attorneys as well as executors is making sure that our debts are paid. And for the executor side of things, so if we've died, before beneficiaries get anything, debts have to be satisfied first. So, making sure that, all of the debts are listed. So, whether that's a mortgage, line of credit, I would also include information like, cell phone bills and utilities and that type of thing. So, just sort of having that list of account numbers would make the lives of the people we leave behind much easier. And it would get things done much faster than if they had to run around, try and find information, call around to see, oh, does this person have an account here? And if so, then, try and get information that way. Last but not least, maintain and keep updated a list of logins and passwords. So again, not asking you to share that information right away with the people you've named, because obviously privacy is very important. But having that list does allow our people to be able to manage, all of our online information as needed, especially in a situation where we've passed away. So there's been in the news a couple of years ago where someone's passed away. The executor contacted Facebook to try and close down the deceased person's account, but the executor didn't have any of the login information to be able to go in and just change the information, or at least to put up a note to say that they've passed away and that type of thing. Facebook would not agree to it. They also said that, they're not a Canadian company. They are not subject to Canadian laws. And so Facebook refused to do anything about it. And the deceased person's account was still up and available for public viewing. So This way, by providing our backup people with our logins and passwords, it will make things much easier for them to manage once we are incapacitated or we're no longer alive. All right, how are we doing on time, Barbara?
We're doing really great. This is an incredible amount of information. I want to just check with folks to see if there are questions now around the POA aspect, personal or professional. One of the things that really struck me is it's not just about getting these particular documents done and getting consent and knowing who's going to do it and get a yes from them, but it's all of the other pieces around it. What material, what information do you need to gather and have kind of easily accessible? Yeah. I remember after my dad died, literally like thumbing through his filing cabinet trying to find his will, and we never found it. So it was, you know, it was a tough go. And there was a lot of ripples from that, but learning curve for sure. Let me just check in. Does anybody have a question? If not, we'll just end early tonight, but I really want to say thank you so much, Jana, for this. I don't know if you have contact information that you can share with us.
I do. I did have a section on estate administration taxes. I don't know if we should go through that quickly since we have a little bit of time. Yeah,
we do. Okay. It's great. Okay.
All right. So, oh, I see there might be a question here.
Yeah, I think I was sort of wrapping up. I forgot about this. I forgot about this section. And so
this
people are beginning to say thank you.
Sorry about that, guys. Okay, so this I reserved if we had some extra time. I wanted to squeeze it in. So estate administration tax, like I mentioned before, it's a tax it's a one-time tax that's payable on death, and that's payable as part of the estate administration process. The estate administration process, also commonly referred to as probate, is the process in which someone who is either named as an executor of a will or someone who's died without a will and now someone from that person's family is stepping up to apply to be the executor of that deceased person's estate. They go through a court process to officially become appointed as the executor of the estate. Before they receive the certificate of appointment, the executor can't really do anything with the estate assets. So like if a house needs to be sold, they can't put a house on the market until they're officially named by court order saying that they are the official point person for the estate. So as part of this process, there is that one-time estate administration tax that's payable. The overall amount that's payable by an estate is 1.5% on the assets of the estate. And why I'm emphasizing the assets and not the equity of the estate is that this tax calculation does not take into account debts owed by the estate unless that debt is secured against a property. So unless it's a mortgage or a home equity line of credit. Any other debts, so whether it's credit card debt, student loans, any personal loan, car loans, that type of thing, we don't get to deduct that from the value of the assets when it comes time to calculate the amount that the government wants from the estate. So let me go to the next slide. Okay, so what are some ways that we can minimize the estate administration tax? So the first $50,000 of the estate assets is not subject to probate tax. Everything after that is subject to that approximate 1.5% calculation. So some ways that we can minimize that EAT payment is if the person has any RSPs, RIFs, TFSAs, pensions, life insurance policies, essentially any type of asset that allow you to name a beneficiary or a successor holder. These assets on our death passes directly to our named beneficiaries. And that means that it bypasses the estate administration process. Other assets that bypass the estate administration process is any jointly owned assets. So if you own a property jointly with your spouse or with another family member, you guys own that property as joint tenants. So both of you own 100% of that property together. It's an undivided interest. Then by virtue of that being a jointly owned property, that passes to the survivor by right of survivorship. And again, that means that the value of that asset is not subject to the estate administration tax. As well, any cash or assets that are gifted while you are still alive. That's so let's say if you had intentions of gifting something to a particular charity, I wanted to earmark $50,000 to Sick Kids Hospital or something like that. But instead of waiting until after my passing, I decide to do that while I'm still alive. So when I do that, then that decreases the amount of assets that are going into the estate administration process, which would then be subject to probate tax. Okay, so an example. So again, using John, his assets as of the date of his death. So he has a house that's worth $2 million that's jointly owned with his spouse. He has a pension worth $100,000, has a named beneficiary. He has RSPs and life insurance that also have beneficiary designations. He has one bank account that's joint with his spouse. He has another bank account that is in his sole name. He has a car that's in his sole name, and he has an investment property that's in his sole name. So the total asset value before we talk about what goes where and that type of thing is 5.09 million. So assets from John's estate that would not be subject to the estate administration tax and would go automatically to the beneficiaries is first, if his spouse is alive at the time of his passing, the house goes directly to the spouse. So this $2 million is exempt. The pension, RSP, and life insurance, because there are beneficiaries designated, again, these assets go directly to the beneficiary and there's no tax that is payable on these assets. And lastly, the joint bank account that he has with his spouse, again, because of the joint nature of the account goes automatically to the spouse. So the total estate assets that bypass the estate administration tax is just over 3.5 million. So I did a quick calculation here that if John's assets, none of these things had beneficiary designations and none of this was joint with anybody. So with a total asset value of $5,090,000, the estate administration tax that would have been payable is $75,600. But because he did have assets that are joint with spouse and also beneficiary designations on various assets, the only assets of his that are subject to the estate administration tax is his sole bank account worth $50,000, his car worth $30,000, and his investment property worth $1.5 million. So the estate administration tax for calculation purposes, so total assets subject to tax is 1.58 million. The tax payable amount is 22,950. So that means there's a difference here of $52,650. So these are some very simple things that people can do to make sure that more money ends in the hands of their beneficiaries instead of the government. So what I would invite all of you to do, even if you don't do documents with me, not an issue, in the next day or week or whenever you have time, double check your beneficiary designations on your pensions, on your RSPs, life insurance policies, TFSAs, all of these types of assets. Sorry, I should mention RIFs as well. All of these types of assets allow you to name a beneficiary. So, if you've set up your RSP account ages and ages ago and you can't recall if you did name a beneficiary or not, now's a good time to get in touch with the bank, double check whether that person that you've designated is still the person you want as your beneficiary. Or maybe you thought you had designated beneficiary, but the bank says, no, there's nothing designated. If there's nothing designated, or if your RSP, let's say, is designated to your state, we lose that tax saving benefit, because then that RSP amount, let's say that 400,000, gets moved over into this bucket, and then it's now subject to tax.
That's powerful. that is $50,000 your family gets that they wouldn't have got otherwise.
Yeah. And like in this particular example, like, some things that John could have considered doing prior to his passing is, maybe he adds his spouse to the investment property. So then if that were to happen, then this 1.5 million gets moved over onto this side, which means assets that we would be paying tax on would just be essentially 30,000, because the first 50,000 is not taxable. So again, that would be, so this is the type of discussion that an estate lawyer would have with their clients in terms of, we look at your situation, we look at your current asset holdings, we may have recommendations for you in terms of, oh, we do these particular things, this is how much we can save, and that type of thing. All right.
Jana, thank you.
I've talked your ears off. Thank you so much for bearing with me and for joining us today. Oh, I did have a question here from Charlene.
Okay, and there's also, also just folks are saying, Asher and Amanda are just saying, thank you so much. This information has been so accessible, which is amazing and really helpful. I can't agree more. And I think that having a bit of information can just get us to step out of a lot of chaos later.
Yeah, absolutely. Okay, so let me read out Charlene's question. So as an executor, when you sign the letter of agreement with your lawyer and have to give them a retainer, where do you get the money from? So the money would, technically speaking, the amount payable to a lawyer to help an executor with the estate administration appointment is payable out of the estate assets. Now, if estate assets are frozen, or if the bank's not letting the executor get access to the money, it may be a situation where the executor may go out of pocket first. And then once they're officially appointed, then they can reimburse themselves from the assets of the estate. Charlene, does that answer your question?
Thank you. Yes.
Okay, great. And then Terry asked a question, how would capital gains on the extra property be affected? So I'm not a tax expert by any means, unfortunately. So, but in terms of capital gains, what I understand how the law treats the instance of death is that on the tax side of things, it's a date of disposition. So if, let's say, using John's example, the house that he had in his name, let's say if it was just in his sole name, he then passed away, it was his principal residence. So because it was his principal residence, and assuming that the exemption is still in play at this future time of his passing, that there would be no capital gains payable up to the date of his death. But if there are gains from the date of his death to when we deal with the property one way or another, then there may be a small amount of capital gains that would be payable. In terms of extra property, then yes, capital gains would get triggered on the date of death. Terry, does that answer your question?
Yes.
All right, great.
These are good questions. Any last pieces for folks? Okay, well, I am now officially going to say thank you. This is really, really great. And certainly if folks want to reach out to Jana, her contact information is here, and we will follow up with a email with her contact information with the slide deck. And so if you need a consult, reach out, and she's going to be there for you.
All right, thank you so much for attending, guys. Thanks for sharing your time with us. And thanks again to Barbara and Redbird for having me.
It's a real pleasure.
All right, take